the roll, and then we'll have a few opening comments and move forward. Hey, Jill, how are you? Thank you.
Good afternoon, Mr. Chairman. We're live. Senator Case,
Excused.
Representative Chadwick,
Here.
Miss Bering,
Here.
Miss Johnson,
Here.
Mr. Large,
Here.
Miss Clayton,
Here.
Miss Returns to War,
Here.
Miss Schmidt,
Here.
Miss Logan,
I'm here.
Co-Chairman Ellis,
Present.
Chairman Larson.
Here.
Mr. Chairman, you have a quorum.
Thank you. Thank you, Heather. So members of the task force, this is kind of winding up this year's activities on this task force as we've looked at what we needed to do to, oh, it looks like Senator Case may be joining us now. I've got a text from that. Let's just make sure before we continue on, Heather, if we could see if he's with us. We're going to wait just a minute here for Cale. Senator Case, sorry. Heather, are you seeing him trying to gain access?
Not yet, Mr. Chairman.
He says that we have him muted. He says he's on the call, and but we have him muted. I see his number, the 3308427. Bill, can you hear me? And it looks like you're with us. If you can just, let's try your audio. So Senator Case, I'm seeing your text. Oh, there you are.
Does that work? Hello.
We hear you.
I'm so sorry. This is so complicated. I'm patiently in the background. So I'm here.
Thank you for taking the effort. We know that you've got a lot on your plate today, Senator Case. Thanks for joining us. We just finished roll call and just kind of getting started reviewing that this is kind of the final meeting that we had planned on for the ICWA task force this year as we identified things in our state ICWA law that we passed this last session, which was Senate File 94, things that we thought needed to be corrected or additions to. We've heard and passed a number of bills out of this task force that the Select Committee on Tribal Relations will be hearing next week. The one item that we had remaining, which had been a bit of a topic that had come up between from Director Schmidt as well, I think Claire Johnson brought this up, was reference to ICWA compliance in our safe haven statutes. And so in our last meeting, where we had struggles with the Zoom meeting, we directed LSO to go ahead and draft a bill to include the ICWA requirements in the safe haven law. And that's the bill we'll be considering today to move forward. And Jill, for your, thank you for joining us late in the game, but this committee doesn't have the authority to sponsor a bill. And so as we make any of these suggested changes, then we have been forwarding our request to the Select Committee on Tribal Relations, which Senator Ellis and one of your colleagues in Fremont County, Amber Oakley, chair, and then they'll be hearing those bills this next week. So before we have David get started on the explanation of the bill, are there any questions? And Madam Chairman, do you have any thoughts before we proceed?
Just a reminder that Select Tribal Relations will be meeting November 16th and 17th in Fort Washakie. We're working with LSO to make sure that whatever bills come out of this task force will be on the agenda. I think I've got it just loosely on there that I will present the bills, but I would just offer the invitation to anyone on this task force, if you want to be part of those hearings, testify in the bills, explain those bills, or whatever bills that our task force recommends, that you're welcome to do that. So just wanted to make that clear, but for the ease of trying to get the agendas out, you'll see my name on there, but certainly anyone's welcome to talk about our work.
Thank you, Madam Chairman. Any other questions from the members before we turn it over to David? Okay. David, could you kind of take us through the safe haven law, what it means, and then what you've done in this draft legislation? And I hope everybody's had, David sent that that draft bill out, which is 24 LSO 0281, working draft 3, I believe, David. And if you don't have it, could you let us know? We'll be referring to it in our meeting today. Okay, David.
Thank you, Mr. Chairman. David Hopkinson with the Legislative Service Office, just walking through 24 LSO 281, working draft 3. This bill comes about essentially to explicitly incorporate requirements that the state follow ICWA within the safe haven statutes. Those safe haven statutes were created essentially to allow an individual to anonymously drop off a child if they are incapable of caring for it, or for whatever reason. It really is designed not to even ask many questions, but just give them a place that they can leave that child so that the child can be safe and can be adopted into a good home for that child, depending on, in order to address circumstances or when someone doesn't really have any other options.
And David, that's from birth up to the first 14 days, correct? There's a time limit on that. Maybe Director Schmidt, if you don't know, maybe Director Schmidt can clarify that. So it can't be a juvenile, it can't be a young child. It has to be a newborn.
Mr. Chairman?
Please, Director Schmidt.
Yeah, a newborn child means a child who is 14 days of age or younger is determined within a reasonable degree of medical certainty.
Okay, thank you. Please proceed, David.
Looking at the draft then, it goes into that safe haven statute first in 1411-103 and amends subsection D, which is the section that would require the parent or parent's designee. It gives them the option to provide information about themselves or the child's medical histories and any identifying information, but it's not mandatory. What this inserts there then on lines 4 through 10 of page 2 provides that the safe haven provider shall ask the parent or the parent's designee whether the child has any tribal affiliation or Native American ancestry, and request relevant information to determine the child's tribe. The parent or parent's designee may refuse to answer, and then the safe haven provider shall not require that information be given. So this just basically inserts a requirement for the safe haven provider to ask if the child has Native American ancestry, but the parent or parent's designee who is dropping off the child does not have to answer. And then at the bottom of page 2, amending 1411-105. This is going into where they determining the placement of that child, and it inserts a new subsection D, which requires that if the child is an Indian child, the court and all parties shall comply with the Wyoming Indian Child Welfare Act, and the department shall serve one of those petitions as required by that act in 146704. So it's simply inserting that requirement to clarify that they do need to be complying with, to the extent possible, the Indian Child Welfare Act. Section 2 on page 3 requires the promulgation of any rules by July 1st, 2024. And section 3 provides that the act would be effective July 1st, 2024, except as sections 2 and 3, which are effective immediately, which would essentially just give the department the option to promulgate those rules right away. And with that, I would stand for any questions.
Questions for Mr. Hopkinson? From the members of the task force? So, committee, I think what I'd like to do is take some public comment, if we have any on this, and then I'd like to handle it as we normally do, which is to move the bill. And so as members of the task force, we won't be making public comment. That will be from those outside the task force. And then if we go ahead and move the bill, then that would be open to each of us to make comments and consider some amendments. So, Heather, I see, do we have anybody requesting to make public comment?
No, Mr. Chairman.
We have a question.
I think we have some, Verna Lynn, when on your end, when you speak, we get a lot of echo. But is yours a question on procedure or a question on the bill? Because you'll have time as task force to comment on the bill as we work.
I apologize. Can you repeat that?
So as a member of the task force, we'll be working the bill. And so if your thoughts or your comments are relative to the bill as a member of the task force, let's postpone that until we start working the bill. If, however, you have a question on procedure, how all of this works, we'd certainly like to get that clarified for you now. Does that make sense? And so the intent of the public, so you're sitting on the opposite side of the desk of what you normally are. Normally this is when you would be speaking in select tribal or judiciary or any of the other committees. But now where you're sitting on this side of the table with us, we want to gather from the public any thoughts that they have, and then we'll have a conversation internally with the members of the task force. Is that okay?
Yes, thank you for that clarification.
Thank you. Not seeing any other, Heather, if you'll help me here, not seeing any other public comments. My question would then be to the task force on your pleasure to move the bill, or what would you like to do?
Mr. Co-Chair, I'll move the bill.
Okay, do we have a second?
Second.
We have a second. So was that Forrest? Were you the second?
Yes, I was.
Okay. So now's a good time to have a conversation. Verna Lynn, can we come back to you? I think you had some questions or comments to begin with before we go through and before we go through and work the bill. So please.
Mr. Chair, this is Waylon. We kind of met on this on Friday at late Friday afternoon. Karen, Claire, and I and Verna Lynn on the amendment. On the part of the D, what our concern is on one of the, it's the line 8, where it says between 8 and 9, it says the parent or parents designee may refuse to answer. We kind of had a concern with that. Karen she can chime in on this. We felt that probably didn't want that in there, but I can let Karen kind of add to that, Mr. Chair.
Karen, please.
Chairman, can you hear me? Turn your volume down. Okay, Chairman, can you hear me?
We can hear you, Karen.
Turn it
You're
all the way
echoing
down.
quite a bit, or I don't know if you might be in the
Okay.
same room as Claire, but we
Okay.
seem to be getting some cross feed there.
Yeah, so we're really close, so that's why it's echoing right now.
We-
So can you hear me right
Yeah,
now?
we can
Okay.
hear you very fine now.
I
Thank
would
you.
like to, Chairman, I would like to add to that comment. We have an issue with that sentence right there, specifically because it really goes back to the beginning of what Indian Child Welfare Act, why it was installed in the first place. One of the cases was that a couple, Native mom and dad had crossed state lines because to go to a different state to adopt a child out. And that is exactly where Indian child welfare became an issue. And so the way I see this and the way I believe everybody else here views it is that we're just going right back to the beginning of what we wanted to fix with Indian child welfare with that one statement. Thank you.
Okay, any other comments on this? And if you have a proposed amendment as we work the bill, we can have that conversation. I've got some thoughts that I'll share with you, but I'd like to hear anyone else as we look at that.
Mr. Chair,
Yes, please, Senator Ellis.
when I read that sentence too, I think I share the concern. And so that is, I guess, the question of why that sentence is in there. So I'm guessing there's a reason. So just wondering what the purpose is of having that sentence in there.
Well, I think what we're trying to do is thread the needle a little bit in trying to maintain what we do with the safe haven law, which is to make that as unintrusive as possible. And if you look at that language, the language really isn't new to that section D, that if you read the old language, the safe haven provider may not require that any information be given to the person relinquishing expresses an intent for return of the child. And so we maintained that position under the safe haven law, but yet made the requirement that if for the healthcare provider or the person that they shall ask, the safe haven provider shall ask, but the person doesn't necessarily have to respond. So just trying to thread the two policies. Director Schmidt, do you have any thoughts on that?
Mr. Chairman, thank you. The way I was reading it was just to conform with the current language and making it permissive. In the safe haven law as it is, we don't want to force parents to keep children if they want to turn over. So we want to make it as easy as possible. However, I understand kind of the concern. I think to delete the language, the parent or parents designee may refuse to answer. I'm not sure where that would put the person who's accepting the baby, in what position, if an Indian parent does not answer. I mean, I don't know what would happen there. That might be a conversation.
Chairman,
Yes, council, return.
if I may add, I just want to, okay. So I totally understand what you're saying, what Director Smith is saying, and but we need to remember this is the Indian Child Welfare Act, and we are. I feel as a courtesy we're including the Safe Haven Act, but I don't believe that that language, that one sentence there, fits with what we're doing here with the State of Wyoming Indian Child Welfare Act. I mean, at least I hope we're all on the same page. I hope that we're all thinking about our Native children here within the state of Wyoming. So unfortunately, the federal government is the one that really has a political tag identity on Native people. So, you know, that's out of our realm. However, we have to be, unfortunately, we have to deal with things differently than mainstream society. And so this is where we need to remember why we're doing this. And so I totally understand what she's saying about making it similar to what is said in the current Safe Haven Act. I see no problem just deleting that one sentence. And then I just want to elaborate. So I came from I came yesterday. I come from Bozeman, and several of the Rocky Mountain region tribal nations came together, and we talked about boarding school and the traumas that it has implicated. All of it goes back to originally taking our children and trying to colonize them. And this is not what we want. These are our children. We are more than capable than taking care of them. We are not a nuclear family. We consist of extended families. There are so many reasons why we need to know what's going on with our children. So I myself, and I'm sure that everybody here sitting in this room, are strongly against that one sentence. Thank you.
Okay, any other comments? So, David, if I could ask you a question. If you removed that sentence, the parent or parent's designee may refuse to answer. So as I'm looking at this, right now, regardless of who the parents are, the safe haven provider is going to have to ask if they have any tribal affiliation. Is that correct?
Correct, Mr. Chairman.
Okay, no indication that there's tribal blood, but every parent that comes in relinquishing the right to that child is going to be asked that question. If we remove that sentence, then what is the parent required to do?
Mr. Chairman, to clarify, which sentence are you referring to?
So on page 2, line 8, and on to line 9, that second sentence, the parent or parent's designee may refuse to answer. If you deleted that language, what then, when the provider asks the designee if the child has any tribal affiliation, and we remove that sentence, what then are the parents required to do?
Mr. Chairman, I think that's a fair question. The, the existing law prior, when you look at what it is currently, they may not require certain information. If you take out that sentence about the parent or parent's designee may refuse to answer, I guess looking at it, and certainly the director may speak better to this, but from the perspective of the provider, what does that mean? Do they then have to wait until they give an answer? Is there going to be, they would certainly need to create some policy on how that provider should try and get that information. What do they do if that person refuses to answer? I don't think the statute is clear as far as, could they throw them in jail, take them to court, that sort of thing? At that point, I don't think the statute is quite that clear on that. And I certainly wouldn't think DFS or the safe haven providers would want to go that far. But I would note, Mr. Chairman, that with respect to requiring that kind of information, the majority of other states, their safe haven laws are kind of silent. Most of them don't mention ICWA or specifically address ICWA requirements. If we take out that language, there may be some concern that someone or a child without or a parent dropping off a child without Native American ancestry is being treated differently than one who is. But I think for the most part, Mr. Chairman, I guess I would defer to DFS's interpretation on what that would mean or the potential implications. But those are just some of the things that come to mind on if we take out that sentence, that may be issues.
Maybe, Mr. Chairman, another way of asking this is,
Go ahead, Senator Ellis.
and maybe Director Schmidt can get to it too. So you have a safe haven provider. If you have a child that shows up, can the safe haven provider ask about the medical history of that child? They're taking this child into custody. Is there any medical history that we need to be aware of with this child? And then if that's the case, I think it's just a matter of how it's all phrased, right? Like you have paragraph D, line 1 that says the parent or parent's designee may provide information regarding the medical history and identifying information. So this is structured a little different, right? It's like an affirmative ask. So I'm just trying to say, like, if we were to structure this whole thing as a requirement of what the safe haven provider asks, like what if it said the safe haven provider shall ask about the child's medical history? Does that run afoul of something? I'm just trying to draw some parallels there. Does that help? Director Schmidt, maybe?
Director Schmidt, any thoughts?
Mr. Chairman, Madam Co-Chairman, I think the point behind pulling in ICWA into this particular conversation is that if it is an Indian child, there's a certain number of steps that we want to take. And we want to know that upfront if possible, so that when placement is made, then we're automatically taking into consideration tribal affiliation, et cetera, before we get to a place where there may be adoption, and then that comes into question. So it's kind of two different reasons. The request for medical information is voluntary. However, in order to be able to make appropriate placement for an Indian child, that information has to be asked and answered. And if they choose not to answer it, then that's our answer. They may not, but we've at least inquired. And I think that's the difference. So it may be that splitting that particular section out into its own subsection may grammatically make more sense in terms of allowing for disclosure of one, but then asking for if there's a designation in the other. So a new subsection H or something at the end might be a better fix to that.
Mr. Co-Chairman?
Please.
I'm just looking at this, like the duty that we're putting in statute is on the safe haven provider to ask the question. I think that the parent or the parent's designee can answer however they want. They can say, yeah, maybe there's heritage, maybe, or no, no way. Or they could say, I don't want to answer that. Or they could say, I don't know. And I think in the practical reality is those are the 4 answers you're going to get. So I don't know why we need to put in there a right to refuse.
Well, and thank you, but I guess that's the point I'm trying to get to with my questions is the intent from the conversation is there going to be a penalty if they don't want to respond? Is there a penalty if they answer incorrectly and is found out later that there was? So if that's the intent, we probably need to know that now. If there isn't, if we just don't like the language that says that they don't have to answer and get rid of that, then so be it. But if there's additional language to enforce or demand a response, then how does that read?
I think as long as you specifically say that there's no penalty or what the response is, I don't think that there's any hook. So, I mean,
Well,
that's just
so-
my reading of it, but I could be wrong.
Absent of language, isn't it that there's no penalty?
Yeah, so I think if you took it out, I don't see any.
Fernalyn?
Yes, so I have a question. What if there is an infant that is not, taken to a local hospital, but say a fire station where there's no identification available whatsoever? So that question wouldn't really pertain to that scenario. However, I think our main concern is to be able to identify and make sure we're not losing any children in that gap for that identification for either tribe. I think that's our main concern, is identification and being able to approach and being able to make that identification in the most respective way. And there was another comment. What was it? And so once identification is made, then the tribes would move forward in the services. But I think it's just that piece. I mean, like I said before, if we had at a fire department, fire station, where does that lie?
Very good. Other comments?
Yes, Mr. Chairman.
Yes, Representative Chadwick.
Given the lead-in sentence to D, I think it pretty much provides for everything that's in the challenged sentence, and by that I don't see any harm, and it doesn't provide for any penalties that I'm seeing should they choose not to provide that information, because it does say may provide information.
Okay. All right. Further comments?
Mr. Chairman?
Please, Donna.
Yes, so I would agree that taking that out would better meet the policy reason of us putting in the shall ask about. I don't think we can meet the deference to the tribes without knowing the child's heritage. And so whatever we could do to encourage that, because I do think that's the big part of ICWA, that we should try to encourage that. And I don't think we have to put what the penalty would be for the same reasons that Representative Chadwick was mentioning too. That first sentence does say may, but I think with these two policies that the ICWA policy for deference based on the child's heritage would trump the inconsistent policy of anonymity for the person dropping off the baby or the parent dropping off the baby in our state statute.
So do you mind if I ask you for clarification? So are you, because we've got two federal acts that come into play here, the Safe Haven and ICWA. And we're trying to bring into our state statutes the ICWA requirements when we know that the child being left by the Safe Haven in compliance with Safe Haven has tribal affiliation. Does removing the language impede or reduce the ability or the intent of the Safe Haven Act?
So, Mr. Chairman, I don't think that it does, because it just complies with all the other language, including the medical histories and identifying information above. But I think it almost waters down the intent of including the ICWA language in the statute by then adding a provision that says you don't have to answer. And it could just be implied in the may part, and that by not having that in there, it actually encourage people to answer unless they had some big opposition to answering that information for some reason.
Okay, thank you. Well said. Any other thoughts, comments? Any other? Okay, we've talked about the provision on page 2 in 1411-103. Any other?
I have one comment, sorry.
Please, Bernalyn.
So we have been pondering a lot of questions and scenarios and such that would that pertains to the Safe Haven as being working in the Department of Family Services. One of the scenarios we have is if we have a child who is brought forward in a Safe Haven manner, we don't have that identification, don't know what tribe, through our current contracts, we service federally if they're a tribal member enrolled or I believe a descendant. However, if we have a Safe Haven case brought forward, how do we determine which tribe, let alone enrollment services, etc., along with the contract with the state of Wyoming, to determine if that child's a descendant or can be eligible for enrollment. So there's a lot of details to that still need to be ironed out and discussed.
Okay, thank you. So any other comments on the new language on 1411-105? That's on page 2. So what I'd like to do, Claire, did you have a comment or?
Okay, hold on real quick. We're trying to switch between laptops. So I just would like to also remind everybody that to be eligible for ICWA, these children have to be either enrolled or eligible for enrollment. So if we have a Safe Haven kid and the parents did not disclose any Native American ancestry or ties, then that child, this whole thing we're adding in a safe haven is null and void, because there's no way we're going to know whether that child is eligible for enrollment. Thank you.
Understood. What do you do? Well, no, I think I've just answered my own question, Karen, so I don't need to ask that. But yeah, I think we understand what you're saying there on the eligibility of that and your desire to remove that sentence out. But in the process of working the bill, okay, we'll go through the rest of the bill, and then if we would like to make an amendment on the bill, then we can do that, and maybe Chairman Ellis will kind of help us with that. So I'm not seeing any other conversation on line 2. And is there any other comment on page, or are there any amendments on page 2 that we would like to consider? I think there is.
Sorry, Mr. Chair, I'm just trying to read Title 14. And maybe, I guess that's just a follow up from Director Schmidt. So when we work on bills like this, it's important to recognize that, we have a statutory framework in place. So when the department gets this information, I think they've got a protocol either through rules and regulation or otherwise of how they start trying to whittle down and determine the tribe's or the child's tribal affiliation. So that's, I think, covered elsewhere. And I'm just trying to look through that, but I just want to hear that confirmation from Ms. Schmidt. This is just trying to close in on one piece of it. There's more to the statute, more to the rules where there's more compliance with ICWA.
Chairman Schmidt or Director Schmidt.
Thank you, Mr. Chairman. Madam Co-Chairman, if I think I understood you correctly, the question is that once a child has been identified as an Indian child, then do we have other things in place that are going to direct us how we act? And yes, that's going to then come through the Wyoming ICWA, the federal ICWA, on what we do. But if we're silent, if nobody's asking the question at the very beginning, and the relinquishment happens to a provider, not to the agency. So the relinquishment, when a child under safe haven is relinquished, it's at a fire station, a hospital, a police department, or any other place that we have designated. So there's a good chance the department itself is not going to know anything about this child once we get them, other than what that provider may have collected from the parents or from asking questions. So it's just the agency's way of saying, we recognize that a relinquished child may be an Indian child, but if somebody doesn't ask, we'll never be able then to, one, make that determination, and two, do the investigation or find out wherever it is to see if the tribe does want to take jurisdiction over that case. And if a tribe doesn't want to take jurisdiction, then yes, we're going to follow the usual protocols and laws that are in Title 14. So it's just that one chance to say, okay, if this is an Indian child, this is the only time we're probably ever going to know that. And if it is an Indian child, then ICWA will take place. We'll go to the tribe. We'll see if they want to take jurisdiction and then move it forward. Did that answer your question, Madam Chairwoman?
Yeah, so there's already a protocol in place, I guess, is what I'm trying to just make sure that I understand correctly. Yeah.
Before you, if I could come back to you, I just want to clarify, Director Schmidt, the importance of us contemplating this language in this section of safe haven is really goes back to the point you made. You're already governed by requirements under ICWA as an agency, but the safe haven providers are not. This places that requirement on the safe haven requires to pursue and to, if possible, determine if this child being relinquished has a tribal affiliation. Whereas if we don't have anything in here, they're not required to do so. Am I understanding that accurately?
Mr. Chairman, that's correct. There's nothing right now that requires any of the safe haven providers to ask any question about Native American heritage.
Okay, and so this is kind of an important conversation for us to all keep in our minds. Is that, we're trying to enhance the ability for ICWA to have an impact on placement as it comes into when a parent wants to terminate their rights, and so we're trying to enhance the ICWA process here. So let's not confuse this with being what's already required of a state agency. So with that, Madam Chairman, did you have some additional thoughts?
No, Mr. Chairman, I think if we're working the bill, I'd be happy to offer an amendment if that's appropriate.
Please.
I'm on page 2, line 8, beginning with the word "the parent" or "parents." Strike those words. Going on to line 9, designee may refuse to answer, period. I would move to remove that entire sentence on lines 8 and 9 of page 2.
Do I have a second? Forrest, did you second that?
Yes, I did.
Okay. So any further discussion? We've had quite a bit thus far on this. So I think we'll go right to the voice. And then because Zoom is so hard, Heather, I think what I'd like to ask you to do is just do a voice vote on this, if you would, please, so that we, because we can't always see everybody. Or unless you can see them, Heather, can you?
I can do a roll call.
Okay.
Senator Case,
Excuse.
Representative
Yes.
Chadwick,
Oh,
Case is yes.
okay.
And Mr. Chairman, assume this is on the amendment, correct?
Correct.
Okay.
That's correct.
Yes, aye.
Miss Baring,
Oh, fuck.
Aye.
Miss Johnson,
Aye.
Mr. Large,
Aye.
Miss Clayton,
Aye.
Miss Returns to War,
Aye.
Director Schmidt,
Aye.
Miss Logan,
Aye.
Co-Chairman Ellis,
Aye.
Chairman Larson.
Aye. So I think we're ready to go ahead and vote on the bill, and task force members, remember that we're just voting to move this bill forward to the Select Committee on Tribal Relations. And so they'll go through this whole process again. So if there's any part of this bill that you feel that needs to be, might have some additional needs in there, you please bring that to Chairman Ellis next week and be ready to go through the debate that you're all doing so well today. So with that, Ms. Hunter, would you go ahead and take a roll call on this bill?
Mr. Chairman, this is a roll call vote to recommend to the Select Committee on Tribal Relations 24 LSO 281, Indian Child Welfare Act, Safe Haven Amendments as amended. Senator Case,
Aye.
Representative Chadwick,
Aye.
Miss Baring,
Aye.
Miss Johnson,
Aye.
Mr. Large,
Aye.
Miss Clayton,
Aye.
Miss Returns to War,
Aye.
Director Schmidt,
Aye.
Miss Logan,
Aye.
Co-Chairman Ellis,
Aye.
Chairman Larson,
Aye.
11 ayes.
Thank you. Thank you, committee. Good debate, good discussion. The next topic on the agenda is District Court Tribal Placement Preferences. And in visiting with LSO, Chairman Ellis and I have had some questions and conversation with Heather and David, and we just want to make sure that we haven't left anything that this task force wanted to accomplish undone that is really that we need to get done this session. And so, David, would you kind of go back and review some of the conversations and we just want to make sure that we haven't left the convenience store without all the kids in the car.
Thank you, Mr. Chairman. So just briefly, there was at the first meeting some discussion and concerns expressed about the district court and specifically the requirements for placement preferences, and some concerns that perhaps there needed to be some changes to those, and to specifically addressing tribal preferences and whether the district court needs to use tribal preferences in placement. In reviewing the statute, in looking at 146707, the placement of Indian children, subsection C there does currently require that if the Indian child's tribe establishes a different order of preference by tribal resolution, then the agency or court making placement shall follow the tribal resolution, as long as the placement is the least restrictive setting appropriate to the particular needs of the child. So there is some existing statute there that they do need to follow tribal preference as long as there's that tribal resolution. And so if there were concerns not addressed by that, Mr. Chairman, certainly those can be expressed, but that's kind of where we were at on that issue.
So committee members, just trying to have you scratch your head and recall some of the conversation on that and see if Mr. Hopkinson's research on that topic satisfies the concerns that was previously expressed, or if there's something that we need to address further. We're just trying to make sure we touch all the bases.
Chairman Larson.
Yes, okay. Go ahead, please, Claire.
So while that does satisfy, the tribes obviously want the courts to look at tribal placement. I guess my question is, how do we make sure that actually happens when it comes to a court case? Because in most of the ICWA court cases here, judges have never asked. It's mostly, having to go in and go, wait, no, the tribe has this. So I don't know if there's a way to put a stronger onus on the judges in these cases to ask, does the tribe have a resolution on placement preferences? And just make sure that they're actually asking.
So in these, my question then, Claire, maybe back to you, just trying to understand the process in the court proceedings. Is the tribe a member of those court proceedings?
Yes, sir.
And are they able then, as the judge makes a recommendation, are they able to comment on that?
We do, and we always try, at least for Northern Arapaho, to give a judge the copy of our placement resolution. We sometimes run into some resistance, unfortunately, when it comes to that.
Chairman Ellis, I guess I'm looking to the legal minds here, Chairman Ellis, and I don't know, is Elise participating by Zoom, if she would, or by phone? I'm just a little curious on the administratively, what the courts, should not the courts be required to consider? Well, we know they are because of statute. So how do we, Elisa, have you heard this concern before? And if not, just any thoughts, or is this something that we need to look at?
Thank you, Mr. Chairman. Sorry, my video does not seem to be working. I think that may be a computer issue as opposed to something else. But just for everybody's information, my name is Elisa Butler. I'm the state court administrator for the Wyoming Judicial Branch. We did run this question through our judges, our district court judges throughout the state. And my understanding based on that conversation was that many of the judges are providing notification to the tribes when these cases come up. As far as the placement preferences, I don't know that I can speak directly to that, but what I would assume is that the judges would take that into account in some way as they're making their decisions. If there's further follow-up that I need to do, I would be happy to do that. I don't know that we would be all that excited about a statutory change at this point. But that is my understanding based on my conversation with the judges in this state. But again, I'd be happy to follow up.
So Lisa, my question is, I think that the language is pretty clear in statute that they do have to consider, and we just want to, I think the question being asked is, how do we ensure that there's not resistance to that consideration to comply? And if they don't comply, that they have, that the tribes receive information as to why it isn't in the best interest of the child, being least restrictive setting appropriate to particular preference of to do that. So we're just wanting to make sure, I think the question is how do we make sure that the judges understand that they do have a statutory requirement to in this regard? Is that a fair question? So I don't know that we're really looking for a statutory change as much as we just wanting to make sure that the judges understand there's that compliance that's required.
Mr. Chairman, I don't know specifics, and even if I did, I'm not sure I could speak to them, but I would guess that most of the judges who encounter these kinds of cases frequently that do involve ICWA are firmly aware of the requirements of the statute. There may be some things that we can do to ensure that that's something that the judges are aware of statewide. But I think that is probably, if it's pointed out to the judges that this is something they need to consider, generally, they would be my assumption.
So, and I think that's what we're saying. That's how do we do the training to ensure that not most, but all judges understand the requirements. And maybe what we could do on this, because I don't think that this is it's a concern, but I think statutory processes in place. Could we maybe have you reach out to Claire and just see what concerns they've experienced, and then see if that warrants maybe some training as you visit with the judges, and if there's additional concerns that we need to address from this task force, then we could look at that then. But I think more than anything, we're just trying to make sure everybody's on the same base. Is that a fair request of you?
Yep, Mr. Chairman, I'd be happy to do that.
Okay. Claire, is that good with you?
Yes, that works for me.
Okay. Thank you.
Mr. Chairman,
Please.
just to add on to that conversation a little bit, I was invited by the Children's Justice Project, comprised of Wyoming judges and some local practitioners, to just provide an update on ICWA. Talked a little bit about how we got to the reason we codified the bill. And then I actually had a lot of questions about the qualified expert requirements in ICWA. And so it got me thinking, one of the comments that I kind of took away was, is this, yet another mandate, an extra thing? And I thought, well, we just codified what the feds already require. There's nothing new. There was no, in my view, need for a new appropriation, because everything we codified is already there. But it got me thinking, like, I do wonder, I think that some of this conversation we're having is just a renewed effort to make sure that training's there, and, there's no ambiguity on what the requirements of ICWA are federally. So I think training is a great start.
Okay. Thank you.
Mr. Chairman,
Please, Donna.
excuse me, Donna Playton. I wondered if, because there are so many federal acts and provisions that judges have to know about and comply with in juvenile court cases, and maybe Director Schmidt or Ms. Johnson would know, but even a bench card or something on ICWA that could be used and distributed to district court judges. I wonder if that might be a helpful thing for us to do.
We like cheat sheets. Anything to help us get along. So I think I think, Madam Chairman, my inclination is kind of leave this conversation in the very capable hands of Mrs. Butler and Mrs. Johnson. And then if need be, come back to us with some recommendations, if they don't feel that they can get where they need to be. I think it'd be interesting, particularly from Ms. Logan and Ms. Playton, as they're working over the next year, as they identify problems, you know, like the one Chairman LSU brought up on who the expert witnesses are, and how are those chosen, and how are those determined, and you know, how is that? Who determines if they're qualified or not? And I don't know that we need to get into that today, but as you guys go through this in practice to help us, it's helpful if we can identify any of the shortcomings that we have. Madam Chairman, would you concur, if I missed something there?
I think that's accurate, Mr. Co-Chair.
Madam Chairman, anything else that you have for the good of the task force?
I don't. I just really want to thank everyone. You know, I don't think any of us really knew what we were getting into when the legislature disbanded this past year. We didn't know how the court was going to come down on ICWA with the Brackeen decision. So thank you for your willingness and the time that you've put in to serve. I think that we've had some good discussion this year, and I think the 2 bills that we'll be taking to tribal relations are important, and I think will make things work better in Wyoming. So thank you for everyone for volunteering your time to help us get there.
If I might just pile on to that a little bit, and also say thank you for all of you, particularly those of you serving out in the public and not in the legislative model, Director Schmidt and Ms. Payton and Jill, for your participation coming in late like you have. And then from our tribal partners, thank you so much. It's always good to have you there. I would just close in saying we have seen a lot of critical Supreme Court and district court decisions on tribal matters the last couple of years. And I hope that we're all kind of paying attention, because it always impacts Wyoming in a significant way, and to be thoughtful as we read the arguments and see what we need to do to make sure that we're maintaining sovereignty that was guaranteed to our tribal nations when this country was created. I would just encourage you all to go back. Chairman Ellis got me to read Justice Gorkich. How do I say his name? Gorsuch. Read his comments on the Brackeen case and the how the federal government has interacted with tribes even before, even when we were under the English law, before we were our own nation. It was always deferred to as independent nations. Read his opinions in the Brackeen case. I think it just really helps establish the importance of this sovereignty issue, and that we sometimes have to step back and say, oh yeah, even 250 years later, we have to respect this just in the same way we respect the Constitution. So with that, thank you all and wish you the best. Happy leaf raking, and we'll close this meeting.